he picked the wrong family, and not scared of a conflict, and we're not scared. We're not running. We're coming at him.
But it just tells the story of it's the evil and the ugliness of people's hearts these days is everywhere.
Hey guys, welcome to the Think Tank. Welcome back. Oh my, what a day. So I am still watching to see if there's any move in the courtroom as far as Alex Murdaugh went. But hey, I kept that stream up. Let me see here. Because what I'm thinking I'm going to do is just record. If I can, just record it, but when I see if I can find anything, still nothing. That's amazing. Like, what? What do you guys think happened there? Why did nothing happen? We sat there for what, an hour and a half? Yeah, sat there for an hour and a half and no movement. I don't know what happened there. So, yeah, what we'll do is look a little bit at what's going on. As far as, what do we got going on here? As far as the Delphi case, let's take another boo. There's a few documents out, a few changes. Oh my word. Yeah, there we go. New Delphi documents.
Net credit is...
But that's not what we're after. Okay, let's check it out. If it's the 11 minutes, we won't. If it's the 11 minutes, we'll just either skim through it or I'll just read through it. Whichever seems to be the best. Okay.
Thanks for inviting us in. It's now 5 o'clock. We want to begin tonight with breaking news in this Delphi murders case. I'm Scott Swan, in tonight for Anne Marie.
And I'm Felicia Lawrence. In just the last hour, we received the documents just filed by the special judge overseeing the Delphi murders case. And our Rich Nye has been reviewing them.
And Rich joins us in studio to take a look at how the judge is now responding to the orders from the Indiana Supreme Court. Rich?
Scott, today was the deadline for Judge Francis Gull to respond in the first of two cases before the Indiana Supreme Court filed by civil attorneys for Richard Allen. And in this case, the attorneys asked the state's highest court to make Judge Gull follow the rules about all court documents being part of the public record unless sealed for a specific reason. Judge Gull responded with a legal brief through her attorney late this afternoon. The judge argues that she did not abuse her discretion in managing the court records. She says most of the...
So what do you guys think? She's been doing all sorts of things that are fairly unusual. Do you think that it's just unusual things happening, or do you think this woman is crooked as shite?
Request is a moot point because she has already ordered most of the documents in the case to be made public. And she says the clerk's office is ultimately in charge of court records, not the judge. So we wait now to see what the Indiana Supreme Court decides in that case. Some court records dating back to June became available for the first time today. We got our first look at letters written by an inmate in the Westville Correctional Facility who says he was housed in a cell.
So we do have this document, so I'll be going through that after we look at a couple things first. Let's see here.
To respond to the request for Allen's attorneys, the original attorneys, to be reinstated to the case. Bradley Rosie and Andrew Baldwin, and Judge Gull also to be replaced as the special judge in this case. That's also the deadline for the judge to provide a transcript of the October 19th in-chambers meeting where Rosie and Baldwin say they were coerced to resign. Richard Allen's murder trial is on hold until all of these matters are resolved.
Okay, thank you, Rich Nye, for reporting tonight.
Yeah, I mean, it's just turning into an ish show. It's sad. You know, we've talked about this a few times about how sad this is for the families. It's absolutely heartbreaking that these families have to go through this for this long and again. It's one of these cases that it breaks my heart. So let's see here. Carroll County, Indiana, the special judge assigned to the Delphi attacks investigation has responded to the Indiana Supreme Court and said that Richard Allen's claim of not having access to all documents related to the case has no merit, and that he has not been hindered in any way from accessing them. I don't know, is this woman just full of crap? Previously, the original attorneys for Richard Allen, Andrew Baldwin, and Bradley Rosie filed several motions with the Indiana Supreme Court after they were removed from the case by Gull in the aftermath of an evidence link. The lawyer asked the Supreme Court to review Gull's handling of the case and accuse her of violating public access by keeping some filings secret, along with claiming she hasn't provided Allen with complete access to all the documents involved in the case. So hasn't she admitted to that to a certain degree? Gull responded on Thursday by saying that Allen and his attorneys were incorrect and had complete access to all documents filed in this case, both sealed and unsealed, despite having ample opportunity. This failure alone warrants this court to reject the petition, Gull said. Gull also argued that the remaining documents under seal have since been unsealed, and that she ordered the clerk to make all non-confidential documents available to the public in action that she argued against another of Allen's petitions moot. Well, I don't know. I don't know if I'm following her on this. Gull points out in her response to the Supreme Court that Allen argued extreme hardship if his petitions were denied. Gull writes that Allen never clearly states that it is he who would suffer extreme hardship if the documents remain publicly inaccessible. However, and instead implies the hardship is to the public. But Gull once more reiterates that Allen has complete access to any court documents regardless of whether they are public or confidential, and that the documents are under seal does not hinder in any way Allen's defense of the criminal charges against him. Further on, Gull goes on to state that Allen and his attorneys have the right to an appeal to remedy any concerns they have. Gull concludes many of her points by once again saying that many of Allen's requests are now moot after directing the clerk to make non-confidential documents available. Gull said that the court also does not have an absolute duty to reinstate documents filed by the attorneys who are no longer represent Ellen. And does not have an absolute duty to reinstate documents filed by attorneys who are no longer representing Ellen. Gull said the court also did not have a duty to provide the public with remote access to records, much less the particular form of remote access requests. Gull also addressed Ellen's attorney's request to unseal or restore public access to the Franks memorandum filed by Rosie and Baldwin. I don't know about this woman. Gull said the Franks memorandum was marked as confidential because it contained the names of minors and put the blame on Ellen's defense team for failing to supply the court with a redacted version. Gull said she already ordered Ellen's new defense team to review the pleading and either adopt them or make their own. If the new counsel does not adopt them, she said they were ordered to file a redacted version. So I don't know. None of this sounds like things I've seen in previous documents, but I might have to really take another look. Let's see what the paperwork looks like when we're done with these and see if any of this is going to make any kind of sense. So Ellen's defense team, Gull saw the Franks memorandum, Gull said she still has until November 27th to respond to Ellen's attorney's request for a transcript of a closed-door meeting from last month. You see, this is the problem. This is where I was saying, you know what? This is not sounding like what we've been hearing. Alrighty. A writ that puts pressure on the Supreme Court by Ellen's original defense to have Gull thrown out from the case. Like, what? So that totally goes against anything we've heard. Like, are you kidding me already? I don't know what to say about that. Inmate claims abuse, intimidation by prison staff watching Delphi suspect Richard Allen. Robert Beston claims he has seen Richard Allen be abused and mistreated by Westville correction officers and staff. Really? So we do have this paperwork. If they don't show it here, I'll be going into that next. Oh my, oh my, oh my. Yes, please.
Thanks for inviting us in. It's now 5 o'clock. We want to begin tonight with breaking news in this Delphi murders case. I'm Scott Swan, in tonight for Anne Marie.
And I'm Felicia Lawrence. In just the last hour, we received the documents just filed by the special judge overseeing the Delphi murders case. And our Rich Nye has been reviewing them.
And Rich joins us in studio to take a look at how the judge is now responding to the orders from the Indiana Supreme Court. Rich?
Scott, today was the deadline for Judge Francis Gull to respond in the first of two cases before the Indiana Supreme Court filed by civil attorneys for Richard Allen. And in this case, the attorneys asked the state's highest court to make Judge Gull follow the rules about all court documents being part of the public record unless sealed for a specific reason. Judge Gull responded with a legal brief through her attorney late this afternoon.
I don't know. Like, does she get a pass? What is she asking for? Like a pass?
The judge argues that she did not abuse her discretion in managing the court records. She says most of the request is a moot point because she has already ordered most of the documents in the case to be made public. And she says the clerk's office is ultimately in charge of court records, not the judge. So we wait now to see what the Indiana Supreme Court decides in that case. Some court records dating back to June became available for the first time today. We got our first look at letters written by an inmate in the Westville Correctional Facility.
Yeah, that's the thing. Like, we're just getting some of these today. I know there's still one I am missing, and I don't know if it came, I think it came out this morning. I haven't found it yet, but I will keep looking for it. Yeah, I'm on it.
Who says he was housed in a cell right above Richard Allen. That inmate says, I have witnessed Richard Allen being abused and mistreated by correction officers. That inmate was scheduled to testify at a hearing in June regarding what he witnessed, but he refused to come out of his cell and travel to Carroll County. He said he had been beaten up by correction officers in retaliation for reporting the abuse of Allen, and he feared even more mistreatment if he testified. Now there's an even bigger deadline.
That is really scary if that is what's happening behind those walls. Like, that's really scary. I mean, as much as we probably don't want anything to do with absolutely any one of them locked up in a place like this, they still have families. And who wants to think of their families' worry and concern about crooked frickin' cops again?
Still looming before the Indiana Supreme Court. That is November 27th. That's the deadline for the judge and anyone else to respond to the request for Allen's attorneys, the original attorneys, to be reinstated to the case. Bradley Rosie and Andrew Baldwin, and Judge Gull also to be replaced as the special judge in this case. That's also the deadline for the judge to provide a transcript of the October 19th in-chambers meeting where Rosie and Baldwin...
So why the hell has she got a problem supplying this? I don't know. To me, that just makes this whole situation look worse.
Say they were coerced to resign. Richard Allen's murder trial is on hold until all of these matters are resolved.
Okay, thank you, Rich Nye, for reporting tonight. We have been following this investigation closely for more than 6.5 years.
We've made it easy for you to find today's developments and our past stories on the case. Just go ahead and scan the...
All right, so an inmate at the Westville Correctional Facility where the Delphi suspect is being held stepped back on speaking about Richard Allen's alleged abuse by guards due to my safety and fear for my life. Yeah, there's no way something like that should ever be happening behind those frickin' walls. So he's serving a 40-year sentence for some yucky stuff in Ripley County. He was housed in a cell above Richard Allen. According to the documents released today, Baston initially agreed to speak with Allen's former attorneys, Andrew Baldwin and Bradley Rosie, during a hearing on June 15th in Carroll County of the mistreatment by corrupt sergeants and officers and administrative staff and mental health. Whoa, the mental health professionals. What the hell is that? In Baston's letter addressed to the Carroll County Clerk of Courts, Baston claims he has seen Allen being mistreated by Westville correctional officers and staff. If that's why he lost all that weight, whoa. Baston wrote in his letter that he took notes on how and when this mistreatment was happening. Baston said those notes were either destroyed or lost or taken to the incriminating recorded dates and times. Destroyed or lost or taken. Unreal. So, good possibility there's still some messed up stuff going on behind those frickin' gates. So this is the letter from Baston. And it goes straight to the Carroll County Circuit Court. Letter to the court. I, Robert P. Baston. And then he gives his inmate number 209210. An inmate at Westville's Restrictive Housing Unit was subpoenaed to appear in the above cause number on Thursday, June 15th, 2023 at 7:30 a.m. in the Carroll County Circuit Court, 101 West Main Street, number 203, Delphi, Indiana, 46923. Due to corruption and retaliation by Westville's Restrictive Housing Unit, staffed officers and housing unit staffed and officers, I had to refuse to appear in the above-mentioned court hearing due to my safety and fear for my life. I was housed in a cell A2-206, just above Richard M. Allen's cell at A1-107. Due to being a voice on how Richard M. Allen was being abused and mistreated by corrupt sergeants and officers and administrative staff and mental health professionals. I hate to say that I don't believe it, but I can see this. I could see it happening. I'm not saying it is, I'm saying I can see it. And it makes me ill. So yeah, and mental health professionals in Westville's Restrictive Housing Unit. I was retaliated against and moved by orders of Warden John Gallipo, Captain Gary Lewis, and Restrictive Housing Unit Manager Miss Tracy Cornett. I was moved to Restrictive Housing Unit B-Pod, Cell 201, after reporting Sergeant Brandon Williams and his officers trafficking contraband to inmates in A-Pod to the Indiana Department of Correction Office of Investigation and Intelligence Internal Affairs in a recorded interview on April 28th, 2023. 5 days after the interview, on Wednesday, May 3rd, 2023, at approximately 7 a.m., Sergeant Brandon Williams and his officers, while I was in full restraints and leg shackles in Westville's Restrictive Housing Unit, receiving area on security cameras will show Sergeant Brandon Williams ordering an officer to put my mattress in urine in a cell that I was placed in the night before without a toilet and running water in the cell. Security cameras will show Sergeant Brandon Williams slamming to the floor and violently breaking my foot and ankle, and then intimidating the nurse not to treat my injuries. When Sergeant Brandon Williams had an ink pen in the STAB vest that he was wearing, pointed me, got me in the elbow all the way to the bone. I was then placed in a cell 201 in B-Pod. Then at 10:45 a.m. on the same date, Sergeant Brandon Williams gave no verbal command to cuff up at my cell 201 B-Pod and dropped the handcuff port in the cell door and sprayed OC pepper spray in the cell and then left me in the cell for 10 minutes, asphyxiating for air. I then was handcuffed and removed from cell out of view of security cameras and taken out in the hallway where an Officer Quentin Davis was waiting and told Sergeant Brandon Williams and officers to hold me up while Officer Quentin Davis violently punched me in the ribs and stomach. This is frickin' horrible. Trigger warning all over the place. Are you frickin' kidding me? Wow. I just, better late than never. This is like, are you freaking kidding me? So while this was happening, Officer Mr. I think it says Motts, kneed me in the face while Warden John Gallipo, mental health doctor Monica Walla, and Miss Bourne were watching the beatdown from outside Captain Gary Lewis's office. If this is the case, there's no way they would have kept that footage. The nurse again was intimidated not to treat my injuries, and I was placed back into cell 201B pod. I was placed on strip cell, and my personal property was taken. When eventually receiving my property back, my legal documents were either destroyed or lost or taken due to incriminating recorded dates and times. Some of those recorded dates and times concern how Richard M. Allen was being abused and mistreated by staff and other officers. Like, I can't see there, if there was footage, I can't see it still being there. So my personal property was left out in the hallway, unsecured, and Westville restrictive housing unit. General population workers and unaliving companions were stealing my property. I recently received from the United States Department of Justice investigative report number 237321 FBW and 247025 TFZ and 264819 LHH. But recently, the U.S. Department of Justice has been in the news for mishandling complaints. The Indiana Governor's Office of Ombudsman Bureau has also mishandled complaints on the Indiana Department of Corrections and the corruption going on in IDOG facilities. The Indiana Department of Corrections Office of Investigation and Intelligence Internal Affairs is allowed to police itself and cover up excessive use of force assaults on inmates by Department of Corrections. Sorry, guys. I also been corresponding with a New York Times investigative reporter and her team at the Yale Law School. I have been sending documentation and evidence but due to the corruption, my legal mail has not made it to its destination. So until this court can protect me and other inmates at Westville Restrictive Housing and report the excessive use of force, assaults, abuse, mistreatment, torture, and retaliation from corrupt Indiana Department of Corrections officers, then I do not feel safe to testify in cause number 08CO1-2210-MR-000001. When a pattern can be shown to the above mentioned issued by researching the named individuals mentioned in this letter in the United States District Court, Northern District of Indiana, 7th Circuit, then clearly shows a pattern of excessive use and force, assaults, torture, abuse, mistreatment, and very poor mental health treatment. Again, I have witnessed Richard M. Allen being abused and mistreated by Westville Correctional restrictive housing unit staff and officers that has affected his health and mental health. I, Robert P. Baston, number 209210, asks this court to report this corruption to the proper authorities to investigate. Respectfully submitted and sincerely, Robert P. Baston, June 25th, 2003. And then gives his housing information. There you go, guys. Like, what? Unflippin' real, man. Motion to leave to appearance as amici curiae. The Indiana Broadcasters Association, Hoosier State Press Association, American Broadcasting Companies, Scripps Company, Janet Satellite Information Network, LLC, the Indianapolis Star, Next Star Media, collectively the Media Coalition. By announcing respective move to leave, open for leave to file a joint brief regarding the limited use of the importance of open courts and access to court records to support, in support of this motion, the Media Coalition states the following. So it looks like there might still be a battle as far as that goes too. Unreal. Unreal. Hey, Melissa. Good to see you, friend. Alrighty. Okay, let's get back. Interests of the... Okay, I don't know how to... When they get into some of this legal wording, I honestly... So in the deposition for the petition for writ of mandamus and prohibition. So HSPA and IBA are associations comprised with the vast majority of Indiana media organizations, more than 400 Indiana newspapers, radios, and TV stations, with a substantial interest in the news gathering process, maintaining an informed citizenry, and ensuring the public's free and robust access to public record, news, information, and matters of public concern and safety. The HSAPA was founded in 1933. Is a trade association representing 165 daily and weekly paid circulation newspapers in Indiana. The HSPA seeks to offer public understanding of the role of the free press in society, to increase public literacy, to enhance the ability of Indiana newspapers to fully educate and inform the public and defend the principles of the First Amendment of the United States Constitution. The IBA is an alliance of more than 300 members, radio, television broadcasters, united to serve their agencies through Indiana. Like the HSPA, the IBA fulfills a variety of watchdog functions and is dedicated to inform the populace, and its organizations are regularly engaged in news gathering and reporting functions in ways that directly implicate access to public records, including court records. The interests of ABC, Scripps, Gannett, Nexstar, and TEGNA are aligned with the IBA and the HSPA as entities seeking to report on issues of public concern. They share the interests of ensuring public access to court records. ABC, Scripps, Gannett, Nexstar, and TEGNA are entities fulfilling the constitutionally important watchdog function of the media. In their news gathering, reporting, and watchdog functions, the Media Coalition relies upon open access to court records. In return, the public has for decades relied upon the Media Coalition to report on matters of public concern. It often is said that the media stands in the shoes of the public. When the media requests disclosure of public information from a state agency pursuant to RTKA, the register then stands in the shoes of the general public, which has the right to know such information. The U.S. Supreme Court has further organized that, beyond question, the role of the media is important, acting as the eyes and ears of the public. The public interest of ensuring open courts in compliance with the access to court records and rules in Indiana trial rules. The issue now before the court directly implicate the extent to which the public is entitled to access, inspect, and copy court records and inform themselves as to the legitimacy of the court proceedings and the criminal justice system. The Media Coalition's participation as, on the matters presently before the court is desirable because of will provide the court helpful context on the issues presented in the petition for writ, particularly addressing implications of issues before the court upon the public's right to access and receive information from court records. The organizations representing the bulk of newspapers and broadcasters in Indiana, over 400 in total, they have a unique perspective on these issues. The Media Coalition stands ready for present information that will assist the court in resolving the complex issues before it while fully taking into account the impact of the petition on media organization, news reporting functions, and the public at large. It is particularly important that the Indiana's media organizations be heard with respect to the petition, as the court's ruling will have immediate and sweeping impact on the news gathering and reporting on a high-profile criminal proceeding that will impact public's trust and the legitimacy of the state's criminal justice system. By informing the criminal court on issues discussed above, will provide the court with necessary and helpful information that will aid the court's disposition of the petition. Appearance of the has not been coordinated or paid for by any of the parties in this action. Neither the party nor the party's counsel has contributed money intended to fund the preparation for submission of the proposed brief, which is being brought solely on behalf of and at the cost of the Media Coalition in an effort to protect the interests of its members and the general public by more fully apprising this court of relevant authority and broader public policy implications of the issues before it. The Media Coalition have only recently learned of the pendency of this petition accordingly. The Media Coalition would seek leave to file the attached joint brief. Wherefore, and again, it's going to do it a few more times. I just don't know how to say it. The Media Coalition respectfully requests the Honorable Court grant them leave to appear and file the attached joint brief, and that the court deem the attached joint brief filed as of today's date. So then there's that. For some reason, I thought they had that all figured out as far as the cameras in this case, but not so much by the looks of things. So I've left the longest one for last. I do believe this is where yes. So this is Richard Allen, the realtor, versus the Honorable Francis C. Gull, special judge. Respondent's brief in opposition to realtor's verified profession. What the hell? Verified petition for writ on mandamus and prohibition. You know, when they get back into the table of contents, there's lots of information gonna be had by all. So all of this documentation will be in, you'll be able to download it from Patreon. How you guys doing? All good in the hood. Okay, I need to hydrate. It's funny, you would expect, like Richard Allen with this case, I would expect more people to be working on this case than what really are. It's surprising to me because it's such a shite show. But it is an important case to be sharing out because we do need to know what's going on in the country. It's tricky when every state is different. But this here, I mean, we're talking about a special judge that is getting her pie slapped. And that came out wrong. That's not what I'm just going to leave it at that. Okay. Getting her fingers or digits slapped. Alrighty then. So this one, 20 pages. And yeah, it looks like we might be doing something on P. Diddy later. On Frankly Frankie. And I'm pretty sure I've got it in the description at this point. I think everything's caught up. Alrighty. Respondent, the Honorable Francis C. Gull, special judge, by counsel and pursuant to Rule 3F of the Indiana Rules of Procedure for Original Actions Rules, files her brief in opposition to the realtor Richard Allen's verified petition for writ of mandamus, prohibition petition. Okay, this is the introduction. Realtor fails to satisfy either the conditions, precedent, or mandatory requirements to even seek a writ, nor does the realtor's petition warrant relief on the merits. Realtor asks this court to order respondents to unseal or to make available on the chronological case summary certain documents in this case. This court should deny the writ. First, by his own admission, realtor has not filed a written motion seeking relief from respondent. Original Actions, Rules 2A and 3A-4. This failure alone warrants the court to reject the petition. Second, for almost all documents at issue here, realtor has not acted expeditiously Original Actions Rule 3A2. Realtor complains largely about events that occurred months ago. Third, realtor has not attempted to demonstrate that denial of the petition will result in extreme hardship to himself. Wow. This woman, I tell you what. Realtor has complete access to all documents filed in this case. Okay, sealed or unsealed. And then she's going to say, oh, but except for these ones. And, I don't really gotta. Oh my God, I'm sorry, guys. I don't like this woman. And it's not because I like a lot of judges. Let's just say that. But I don't like this woman. I don't. I don't like her. She just is kind of a biatch, in my personal opinion. So let's see here. Second, for almost all of the documents at issue here, realtor has not acted expeditiously. Realtor has not attempted to demonstrate the denial of the petition. Realtor has complete access to all documents. And realtor has not demonstrated extreme hardship to anyone else. Original Action Rule 3A5. What about that guy that's writing you letters? Does he matter? The fact that he came in with food all over him, down to the weight of a feather? Even if this was his own doing, she should be looking into that. Why? What's going on? You don't just let that fly. I mean, the guy looked like shite. So at least take a look at it. This has got to do with two little girls that were brutally attacked. It's not about this woman. And I don't know if she can accept that. Has not demonstrated extreme hardship. So why is he, I'm curious, why has he literally been approved a transfer that's never happened? Despite about public access to court records are governed by normal rules of procedure, evidence, and appeal. Realtor's remedies available on appeal are wholly adequate. Available to the realtor. Indiana rule on access. Let's go back here. Original Actions Rules 3A6. Disputes about public access to court records are governed by the normal rules of procedure, evidence, and appeal, all of which are available to the realtor. Indiana rule on access to court records. For these reasons, the petition fails procedurally. On the merits, realtor's petition also fails. Most of the relief realtor seeks is now mute. Realtor has directed the clerk to enter on the CCS and make publicly available on all non-confidential documents that realtor requested to be made public. Moreover, respondent is under no duty to maintain the CCS. That is the clerk's responsibility, Indiana Trial Rule 77A1 and 77B. So is this the same one that said that the judge told her not to turn that into a transcript? Just curious. Nor does realtor identify an absolute duty respondent violated. Okay. Realtor is wrong when he suggests that the parties agreed that the documents would be sealed without valid grounds to do so. Nothing of the sort has happened here. Finally, it bears emphasis that the court has never issued a writ granting the type of relief realtor seeks here. Writs are reserved to provide extraordinary relief, not to manage CCS. I'm really curious to see where this is going to go. The Supreme Court, they're doing our streets, has the power by writ of mandate and prohibition to confine a lower court. Writs of mandamus and prohibition are extraordinary remedies which are viewed with disfavor, and many not be used in substitutes for appeals. Original action, and gives her example. This court will not issue a writ unless the realtor has a clear and unquestioned right to relief, and only where the trial court has an absolute duty to act or refrain from acting. So, argument. Realtor does not meet the conditions, precedent, or mandatory requirements to seek a writ. Realtor has failed to satisfy the conditions, precedent, or mandatory requirements for filing an original action. Based on its procedural deficiency, the petition should be denied. Realtor admits that he failed to comply with conditions precedent for original action to seek relief from the trial court. Original action rules 2A and 3A4 require realtor before filing this petition to first raise the issues presented here to the trial court in a written motion. Realtor admits he did not do so. Petition at He did not file a motion with the trial court seeking to unseal or make public any of the documents identified in this petition. Right? No, I don't. Oh boy, oh boy, oh boy. The court should not entertain realtor's petition for this reason alone. Original Actions Rule 2A. Realtor requests that he be excused from this condition precedent due to extraordinary circumstances and a practical impossibility. Petition at Neither is exception under Rule 2A, and realtor cites no authority to support such an exception in original actions. Rather, realtor suggests that the Indiana rules of appellate procedure allow for excuse of an analog. Okay, my tongue's not going there, guys. I'm sorry. Condition precedent under extraordinary circumstances. The rule of appellate procedure do not apply to original actions, which are governed exclusively by their own rule. Original Actions Rule 1B. Moreover, realtors claim that there is an impossibility of performance of the condition precedent is wrong. Petition at realtor asserts that the trial court refuses to accept any filings made by attorneys Rossi and Baldwin and orders the clerk to remove anything they file. Realtor's brief and supportive petition for writs of mandamus and prohibition. So we have gone through all of this. And I am going to have to see if I've got that in Patreon. Let me see here. Let me take a look when I'm done here. Okay, so the trial court has not prohibited realtor for filing motions with the trial court via his current counsel or himself. Realtor is highly competent counsel, including the attorneys who filed the petition. In addition, so are we talking about her friends? Like her little buddy there? Liberato, is it? Okay, not prohibited realtor from filing motions with the trial court via his current counsel. Trial court has appointed new counsel for realtor in the trial court case, as realtor acknowledges. Nothing prohibits any of these lawyers from entering appearances with the trial court, including limited appearance on the issues presented in this petition, but the narrow purpose of first requesting relief from respondent realtor cannot claim impossibility because he directed his current counsel to file a premature and incomplete original action. Finally, as discussed further in the next section, realtor seeks relief arising from the respondent's actions as early as June 2023, indicating a trial court order dated June 28, 2023. Petition at PP 9-8 between June 28, 2023 and October 27, 2023, when realtor received notice that the trial court had stricken filings from Rossi. Realtor had ample opportunity to file written motions with the trial court challenging the court's decisions, but realtor never did. Realtor's compliance with Rule 2A was not an impossibility factually, legally, or practically. The court should deny the petition for this reason alone. Oh my word. Lordy, lordy. Lordy, lordy. I'm gonna hydrate and get back at it. What do you guys think of all this? Pretty brutal, eh? Yeah, I'd be up to watching Adam Montgomery as well. I don't know when he goes to trial at this moment either. Person's throat gets so dry, it's like yeah, you know what? That's with all this stuff, it's like they're destroying the case. Realtor failed to file his petition expeditiously. Original actions of mandate and prohibition must be expeditiously filed. State Rel versus Hashfield versus Warwick Circuit Court. Okay. Original actions rule, although no specific statutory provision prescribes the time for judicial review, such action must be brought expeditiously and without unnecessary delay. For example, this court has found that a delay of 42 days was too long to seek a writ with this court. What? Oh my God. Are they just gonna is she gonna spin laws? Is that what she's gonna do? Just spin a little web? Realtor badly asserts the application has been made expeditiously, but realtor seeks relief from actions that occurred in the following dates. June 22nd, 2023, filing by Carroll County Sheriff. June 28th, 2023, trial court order. July 5th, 2023, Letter from DOC inmate, September 18th, 2023, Allen's Frank's memorandum that she already said she hadn't finished. October 25th to 26th, 2023, Allen's verified notice of continuing representation, motion to disqualify, proceed for transcript and motion for continuance, petition at PP 9-10. You know, I think stuff may have started coming out at a certain point, but it is never, and none of this stuff has ever, as far as I know, been at least taken in front of the court. You know, it's almost like she's full of crap. A realtor filed his petition on October 30th, 2023. Okay, but this stuff only really happened, the middle of October, if that? There was 42 days after realtor filed the September 18th memorandum. I don't think that's what they're frickin' talking about. The exact same delay, and the Supreme Court found to be excessive in 19th hole. The delays from July 5th letter, 117 days, June 28th order, 124 days, and the June 20th filing, 132 days, are even longer. Realtor has offered no justification for these delays in filing an original action. Realtor's petition is expeditious only to the extent that it seeks to reinstate the October 25th, 26th, 2023 filings. However, Realtor's request for this minor relief, no, cannot save his otherwise untimely petition. This court should not issue an extraordinary writ on matters that the trial court decided months ago and that Realtor never challenged before the trial court itself. Realtor fails. I'm going to blow my top, so I'm just going to read. Realtor fails to show that the denial of petition will result in extreme hardship. All petitions shall state facts showing clearly that the denial of the petition will result in extreme hardship. Original Action Rule 3A5, writs of mandamus and prohibition will not be used unless the realtor can show a clear and obvious emergency where the failure of the Supreme Court to act would result in substantial injustice. It is not the policy of the Supreme Court to issue these extraordinary writs against lower courts on slight occasions, but only in special cases to prevent impending injury. Still reading. Oh my God, guys. Realtor petition claims as explained below. Okay, I'm just going to say it. My opinion personally, scrap everybody, start from scratch, because this case is so fudged up at this particular time. Oh my God. I'm looking forward to seeing what the court has to say about this, because I'm not a legal eagle, not even a little bit, but to me it seems like maybe a lot of this is like, it's just playing with words. It's just wordplay. Oh yeah. So here we go. Realtor's petition claims explained below in the accompanying brief. The denial of the application will result in extreme hardship. Realtor never states any facts in either the petition or brief showing clearly that he would suffer extreme hardship. The petition is insufficient under original actions rule. Instead, Realtor argues that restricting access to the court records at issue generally harms the public, but stops well short of arguing that it causes the public extreme hardship. More importantly, Realtors never alleges that he would suffer extreme hardship if the documents at issue remain publicly accessible, nor can he, as a party, Realtor has complete access to any court documents regardless of whether they are public or confidential. The documents are under seal does not hinder. So are they saying that they've got the documents from this closed session? Is that what she's trying to say? The documents are that are under seal does not hinder any way the realtor's defense of the criminal charge against him, although realtor raises arguments about his Sixth Amendment right to counsel. These claims of harm have nothing to do with the relief he seeks in the petition. Realtor fails to show that remedies available by appeal will be wholly inadequate. All petitions shall state the fact, showing clearly that the remedy by appeal will wholly inadequate. Action Rule 3A6. If a court decides erroneously to remedy as through an appeal. Far too frequently, writs of prohibition and mandate are sought to be issued as a shortcut to an appeal on the merits, which cannot be done. Realtor's petition asserts that his remedy available by appeal will be inadequate, but Realtor again fails to demonstrate why the appellate remedies would be inadequate wholly or otherwise. The Indiana Access to Court Records rules specifically contemplate parties must use the ordinary appeals process to resolve disputes arising under this rule. Access to Court Records Rule 1. For that reason, this Court of Indiana Court of Appeals regularly entertain appeals regarding access to court records. Addressing on appeal from a judgment of the Superior Court. Whether trial court properly complied with Administrative Rule 9 when it ordered certain court records excluded from public access. Indeed, Indiana's appellate courts regularly decide the type of issues regarding access to court records that the petition raises. Addressing application of Administrative Rule 9, predecessor to Access the Court Records rules to trial courts, order limiting the use of court records and barring its broadcast or dissemination, an appeal by intervener media entity. Indiana CT 2017 addressing application of Administrative Rule 9 in is my tongue going to do it? Interlocutorly? Appeal of the trials court denial to seal case records. Addressing issue whether the trial court erred under administrative, good Lord, guys, Rule 9 by excluding from public records motion of a party's deposition testimony, and whether the trial court erred by concluding that certain materials obtained by appellant during discovery and filed in court should remain confidential under Administrative Rule 9. Addressing appeal of trial court summary denial of appellates for petitions to restrict the disclosure of arrest records under repealed statute of former Administrative Rule 9. Addressing application of Administrative Rule 9 in context of appellate's request to anonymously pursue name change Indiana rule of appellate procedure reinforced that the realtor may request the relief he seeks from a trial court, and if the trial court disagrees, seek a remedy through a normal appellate process. Any disagreement that arises as to whether the clerk's record or transcript accurately discloses what occurred in the trial court or administrative agency, any part may move the trial court or the administrative agency to resolve the disagreement. The trial court remains jurisdiction to correctly or modify the clerk's record or transcript. The trial court retains the jurisdiction to correct or modify the clerk's record of transcript at any time. Okay. So, reply brief is due to be filed. After that time, the movant must request leave of the court on appeal to correct or modify the clerk's record or transcript. The trial court or administrative agency shall issue an order which shall become part of the clerk's record, that either 1, confirms the clerk's record or transcript reflects what actually occurred, or 2, corrects the clerk's record or transcript, including the chronological case summary if necessary to reflect what actually occurred. If realtor believes that CCS is inaccurate or incomplete, or that documents should be sealed, Rule 32 of the Indiana Rules of Appellate Procedure provides still another avenue for addressing such concerns. Do you think she's worried about her sorry butt? Is this why she's just trying to say lower court, lower court, lower court? Due to the petition's multiple procedural defects, the court should decline to issue a writ and need not consider the petition's merits. The petition fails on the merits. If realtor had satisfied the conditions, precedent, and mandatory procedural requirements for an original action, which he has not, the petition fails on the merits. At the outset, most of the relief realtor seeks is now moot. Respondent has issued an order directing the clerk to make available to the public on the CCS all non-confidential documents. Realtor requests be made public. In any event, respondent has no absolute duty to maintain the CCS. That is the clerk's responsibility. So she ditching this on her clerk? Nor does respondent have an absolute duty to reinstate documents filed by attorneys after they have no longer represented the realtor. Respondent has no absolute duty to provide the public with remote access to records, much less the particular form of remote access the realtor requests. This court should deny the petition. Most of the relief realtors seek is moot. November 14th, 2023. The trial court issued an order that resolves most of the public's access issues raised in the petition supplemental record PP 5 through 6. First, respondent has ordered the Carroll Circuit County Clerk to put the 118 documents previously made remotely accessible by the court order of June 28th, 2023 on the CCS ID at 5. Second, the respondent has ordered the clerk to unseal the June 20th, 2023 filing by Carroll County Sheriff and the July 5th, 2023 letter from DOC inmate. And we just went through that, and place them on the CCS. So all that's come out really is what, 3 more documents? Third, respondent has ordered the clerk to place and make accessible on the CCS the October 25th and 26th, 2023. Oh, really? Has ordered the clerk to place and make accessible. So what is this? County, Circuit County? I don't know. That 25th and 26th filing. So that's what they've been after, right? It's a dry mouth, guys. My eyes are gonna cross. All right. Third, respondent has ordered. Okay, that's what we're on. Files by Rosie. These filings remain stricken from the record and will not be considered because they were filed by an attorney who is not an attorney of record. What? What? Oh my God. On the date of filing, not it. That's how she's doing this. Wow. The trial court's November 14th, 2023 order renders most of the issues in the petition relating to the documents moot. The clerk, not respondent, is required to maintain the CCS. Yeah, and the rest goes on the clerk. Respondent has no absolute duty to maintain the CCS. The clerk of the Carroll County Circuit Court, not the respondent, is responsible for maintaining the CCS. But she told her not to, if I remember correctly. Allegedly, I believe. The clerk of Circuit Court shall also maintain the following records as specified under the rule. Chronological case summary. B, the case file. The clerk of the Circuit Court shall maintain a sequential record of the judicial events in the proceedings. Indeed, Realtor concedes that the trial court clerk is to maintain the trial court case records. Verified petition, BR, at page, I believe, P15. Similarly, Realtor repeatedly refers to the person who has allegedly violated the duty to provide public access to certain records as someone, see petition, someone within the court system. Changed all of Allen's filings to confidential. Someone in the court has since excluded the Franks memorandum from the CCS altogether. Realtor allegations against someone have no basis for writ against respondent. Respondent did not abuse her discretion in managing the docket, much less violate an absolute duty. The trial court has broad discretion in managing its docket. Declining to second-guess the trial court for allowing one motion to be filed but not another, respondent has no absolute duty to manage its docket in the manner sought by the realtor. Nor does respondent have an absolute duty to provide a particular type of remote access. See petition at 162130. Indiana law does not require court records to be remotely accessible. While this section encourages courts to make the designated information available to the public through remote access, this is not required. even if information already exists in an electronic format. Respondent has ensured that the 118 documents on a zip drive have been and remain publicly available online since June 28th, 2023, except for the ones that she doesn't want, I do believe. The June 20 and July 5th documents appear on the CCS record. Even if they are not accessible online via the CCS, this does not mean they have been otherwise excluded from public access. A court record may be publicly available even if the public is unable to download it from the CCS. A court record is excluded from public access only if the record is not available for public access in the courthouse during regular business hours established by the court. In any event, the request is moot for the reasons discussed above. Realtor further asserts that respondent wrongly allowed the parties to agree to exclude certain records from the court's CCS. Nothing like that happened. In the trial court's June 28, 2023 order, respondent explained that the court had an undisputed legal basis for sealing certain records, including the unredacted affidavit for probable cause, listing names of juvenile witnesses, the transport orders for security purposes, and defense ex parte motions and related orders pursuant to long-established case laws. The parties did not agree among themselves to exclude these records without valid legal grounds, nor did respondent rely on Trial Rule 26C, protective order to justify exclusion. Respondent harmlessly noted that the parties agreed with the court's state legal basis for sealing the records. Realtor also seeks to unseal or restore public access to the Franks Memorandum. Now, we have gone through the Franks Memorandum. It took us a while, but we got through it. So the Franks Memorandum contains the full first and last names of the deceased minor children who are the crime victims in this case. Names of minor children are required to be redacted from court filings in federal courts. Indiana, in turn, excludes case records declared confidential or excluded from public access pursuant to federal law, Indiana Access Court Records. Therefore, the Franks Memorandum is marked as confidential because counsel fails to supply a redacted version at the time of the filing. Respondent has ordered Realtor's new defense counsel review the pleadings and either adopt them or make them their own. If counsel adopts them, they are ordered to file the redacted version. And do you know what? I mean, her little buddy, Libretto, and his little buddy, name not coming to me. It's probably because I'm just not impressed, not worth retaining at this point. I mean, what the hell? They're going to, I'm sure, come up with something that almost seems, I don't know, I hate to even think this, but it's more likely that they're just going to follow along with what she would like to see. This court has never mandated that a trial court reinstate documents filed by attorneys who no longer represent a party, making documents available to the public on the CCS when the trial court has already made those documents publicly available, or comply with certain access to court records, rules, or statutes. Realtor's petition does not seek the extraordinary relief reserved for an original action. Should this court grant a writ to the realtor, the court will become inundated with petitions alleging that trial court across the state committed a technical violation of the access to court records rule. Disputes of the of the type a realtor raises are best resolved by the ordinary appellate process, the court should decline to grant the relief requested. Respondent, the Honorable Francis Siegel, our shithawks, respectfully requests that this court deny the realtor's verification petition for writs of mandamus and prohibition. So that's how she dealt with that. I mean, okay. Whatever. She's Oh no, Megsie, have you been busy? Busy? So I will be putting these documents, into Patreon. Boy, I don't even know. Let's just hear, I guess I'm just going to wait and hear what the Superior Court has to say about all this, because I don't have the education behind me to know. But to me, that just seemed like a bunch of mumbo jumbo. And has she covered her butt? Because she's gotten rid of them? Has she covered her butt as far as those documents go? I hope not. Okay, guys. Well, thank you very much for being here with me. I appreciate you guys, and I'll see you in the next one. Bye.